just when you think that the whole Kyle Rittenhouse dealio with the riots and all is going to subside, well, we got another case that's coming along, and it's going to stoke the fires even further. This has to do with the shooting of a motorist by a man named Theodore Edgecomb. This happened in Wisconsin, and Theodore is claiming self-defense. Now, a lot of people are comparing Theodore's plight with the police with Kyle Rittenhouse's because Theodore is black. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnnie Walker Dread to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnnie Walker Dread Show.
All right, let's read this. New video documents raised questions of self-defense and lawyers killing. And let's just go ahead and play this.
It's video likely to be key evidence in Theodore Edgecomb's trial. September 2020, Edgecomb, riding his bike, makes a right turn from Brady Street onto Holton. An SUV makes that same turn, stops, and a man identified as Jason Clearman gets out. Video shows Clearman reach out.
Notice that everything gets really blurry here. I don't know if they intentionally blurred that out because it's a crime scene or what, but this is the kind of crap that allows people to just use their imaginations to figure out what happened. If they have access to a really good video, show it to us or don't show us anything. I'm kind of tired of this.
We've stopped the video just as he's shot and falls to the ground.
We believe that this is a clear case of self-defense.
Well, I don't know if it's clear. I couldn't see squat in that video. Maybe they have better video. I don't know. But when I look at it, I'm thinking, man, I have no idea what's going on here.
Edgecomb's attorneys argue Clearman was drunk and the aggressor, which forced Edgecomb to fire. Court documents allege Clearman and his wife had to swerve around Edgecomb moments earlier and claimed Edgecomb punched Clearman through an open window and took off.
I feel that justice will happen for my son. This should not have never occurred. My son is a very humble person.
Gee, I wonder if this lady has any kind of empathy for Wendy Rittenhouse. No, I doubt it. And by the way, I don't really care if your son is humble. I'm looking for nonviolent. That's the kind of character I want to see in your son. Nonviolent. I don't care if he's humble. This is self-defense.
And anybody that knows him knows that this is not his character.
Supporters also drawing parallels to the Kyle Rittenhouse trial. Jurors acquitted the Illinois teen who claimed self-defense when he shot 3 men, killing 2 during the unrest in Kenosha last year.
Theodore Edgecomb deserves the same right that Kyle Rittenhouse got. He deserves to be able to ride his bike throughout downtown without being pursued, without being stalked.
Edgecomb's.
I bet you if you ask that person, well, so are you saying that Kyle Rittenhouse is innocent? Oh, hell no, he's guilty. So you see, this whole thing about he wants the same justice for Theodore as Kyle got, it's really not quite what they mean. They want Kyle to be convicted, but they want Theodore to be acquitted. Now, we're going to take a look at the facts in the case as we know them so far and do a comparison between those and the Kyle Rittenhouse case. Is it true that because Kyle was acquitted, that Theodore should also be acquitted? We'll see.
Attorneys signaling they will call John Black, the same use of force expert Rittenhouse's attorneys called in his trial last month.
I will guarantee you that if the judge tells John Black that you cannot talk about what is self-defense, you cannot talk about what would be considered a reasonable belief and all that, all you can do is just talk about the timing of the sequences. They would howl. They would say, I don't understand. Here you have this expert that the defense is bringing in, and they won't even let the man talk. Yeah, but they had no trouble with John Black's testimony being squelched by Judge Bruce Schroeder, did they?
As far as Dr. Black goes, we only learned about him through that trial, and he's very well qualified. He has a very extensive resume. He's testified numerous times.
Ben joins us now live from Holton and Brady Street tonight. Ben, it took police months to find Edgecomb.
Oh, wait a minute. Now, they had to go and hunt him down. Gee, I thought that fleeing the scene of a crime meant you were guilty. Of course, that's baloney. The fact that Theodore fled doesn't mean he's guilty. But they sure didn't have any problem claiming that Kyle was guilty because of it.
It did, Joyce. Police arrested him in Kentucky
In Kentucky, wait a minute. Did he cross state lines? Oh my God, that makes it a federal offense. No, not really. It might. If he was a fugitive from justice and he ran across state lines, it might. I don't know. I'm not familiar with that area of law. Therefore, I don't go shooting my mouth off about it, unlike people who talked about, oh, those state lines when it came to Kyle Rittenhouse. So you see, sometimes it's just a good idea to know what you don't know. And by the way, do you think the fact that Theodore traveled across state lines is now going to be brought up as an argument for him being guilty? Do you really think that? Do you think that Black Lives Matter and all these liberal activists that wanted Kyle Rittenhouse convicted, do you really think that they're now going to say, well, now he did go across state lines, and that means that he must have broken, he must be guilty. Only a person who's guilty would cross state lines and fleeing the police. Of course they're not going to say that. All of a sudden, the border between states will be no big deal, which it shouldn't.
March, 6 months after that shooting right here on the Holton Bridge. His trial is now set for early January, and Joyce, Edgecomb's defense attorneys say that he is expected to testify in his own defense.
It took them months to find him, but they made a big deal out of the fact that Kyle didn't turn himself into the police immediately. He didn't turn himself into the police until the next morning. Of course, the next morning was only a few hours later because guess what? He had gone home like 1 o'clock in the morning or something like that. So it took Kyle a few hours to turn himself into the police, and everybody said, oh, he should have turned himself in immediately. Here, this dude fled for months, and they finally caught him. Do you think that long time span is going to be used against him? Oh, hell no. So let's go ahead and read up what happened here. When Theodore Edgecomb shot Jason Clearman on a Holton Bridge in Milwaukee last year, he did so in self-defense. Edgecomb's lawyers contend in court records which detail a new narrative for a jury to consider in the deadly September 2020 encounter. September 2020, the month right after Kyle Rittenhouse shot those dudes in Kenosha. Interesting. Documents filed by Edgecomb's lawyers in recent months claim the criminal complaint against their client did not include critical information they believe supports their approach of an affirmative defense. Okay, we've talked about affirmative defenses, but we're not going to go into it. Self-defense is the most common one. After reviewing the case file and discovery materials, a much clearer picture and sequence of events establishes a credible self-defense claim and cuts against the state's theory that this was a road rage incident, the defense lawyers wrote in a September 2021 filing. When prosecutors filed the reckless homicide charges, where have we seen those before? That's right, those were the charges against Kyle Rittenhouse for shooting Joseph Rosenbaum. The complaint was based in part on the statement of Clearman's widow, who was driving the couple's SUV the night of September 22nd, 2020. In the complaint, prosecutors said the woman claimed she initially had to swerve the SUV to avoid hitting Edgecomb, who was on a bicycle that night. What the heck? She recalled her husband saying, I don't think that's what he said, but okay. According to the complaint, she said when they stopped at the light at North Humboldt Avenue and East Brady Street, the bicyclist pulled alongside them on the passenger side, leaned into the front window, and asked Clearman, "Are you talking to me?" She said her husband said, "Well, yeah, I don't see anybody else, right?" And Edgecomb punched Clearman and rode off. The complaint references a security video that captured what unfolded next. Now, suppose this punch did occur, okay? All those people out there that were claiming, Well, Kyle provoked the attack. He was out there walking around with that rifle, making people feel uncomfortable. This dude actually might have punched Claremont. Now, keep in mind, he also rode off. That means he gets to reassert his self-defense rights. In other words, just because you got punched doesn't give you the right to go chasing somebody to try to exact revenge. Okay? So a self-defense claim could still hold up even if Edgecomb punched Claremont first. But I'm giving him a lot of benefit of the doubt here. A benefit of the doubt that was not given to Kyle Rittenhouse, who, well, he provoked it, therefore he cannot claim self-defense. That's horseshit. But those people who made that claim are not going to use it on Edgecomb. They're going to say, well, he didn't have to follow him. I mean, he could have just called the police or something. Gee, in other words, just like Joseph Rosenbaum didn't have to chase Kyle that night, no matter what Kyle did, if anything. See how the hypocrisy is going to get really bad here. The complaint references a security video that captured what unfolded next. WISN 12 reviewed an edited copy of the video, which was provided by a source who asked not to be identified. The video shows an SUV following a man on a bike onto the bridge before a person steps out of the passenger side of the SUV. The person is identified in court records as Claremont, who was seen walking toward Edgecomb, who was identified as the person on the bicycle. Edgecomb's lawyer said their client will testify Claremont was the aggressor and rushed toward him in a fighting stance, yelling a death threat with a racial slur attached. Okay, let me tell you something here. Whenever they're going to make up a story, they're always going to say that. They're always going to say, he called me the N-word. Okay, it may have happened, but just because he's claiming it did doesn't necessarily mean it did. I'm going to kill you now, slur, and you know what the slur is. The September filing said Edgecomb recalled Claremont saying before raising his arm, by the way, let's be clear, calling somebody the N-word is not provocation as far as eliciting deadly force, because it's not unlawful conduct. So just because somebody calls you the N-word doesn't mean, at least in Wisconsin, that you can use deadly force against them. After Claremont's arm lifts, he is seen falling to the ground, according to the video. The document also referenced police reports which claimed investigators found a folding knife in Kleeneman's front pocket. So here it is. Derek Rose, I suppose, is the attorney. And the knife defense lawyers say, I guess not, new. The knife defense lawyers say Jason Claremont had when he confronted Theodore Edgecomb before TE shot JC. While he did not see the knife, as it was in JC's pocket, he had the reasonable belief that JC was armed, which is confirmed by the evidence in the case. That's really, really, really bad logic there. Okay, so I'm going to have to tell this person how this is supposed to be phrased. If Theodore Edgecomb never saw the knife and never had any sense that there was a knife actually in the pocket, you can't claim that he had a reasonable belief that JC was armed. Sorry, it doesn't work like that. He had a reasonable belief that JC might be armed, because after all, if he's wearing pants and he's got pockets, he could have a dangerous weapon in him. So he could be armed, but he wouldn't be able to claim that he had a reasonable belief that JC was armed, and that is huge in self-defense. If he never saw the knife, can't open fire. Sorry, you just can't do that. You have to have a reasonable belief that your life is in danger or that you face serious bodily injury. And if he didn't see the knife, then he had no reasonable belief that JC had one on him. Now, if JC is a lot bigger, where getting into a fight was likely to land you in some serious health problems, then you might be able to make a self-defense claim on those grounds. So there's the knife. I don't even know what that is. I'm not a knife person. Does anybody know what the hell that is? I don't know. The discovery was not previously made public by police or prosecutors and was not included in the criminal complaint against Edgecomb. Mr. Edgecomb will testify at trial that given the nighttime hours and that it was dark outside, he saw Clairman reach for his pockets before he shot him once. But this doesn't make any sense. You would think that the nighttime hours and being dark would make it harder for him to see it. So let me read this again. Am I reading this wrong? Mr. Edgecomb will testify at trial that given the nighttime hours and that it was dark outside, he saw Clairman reach for his pockets before he shot him once. I don't understand how the lawyer is phrasing that. I mean, that's just strange. You would normally want to say, given the daylight hours and the ability to see easily, then he could see him reaching into his pocket. But okay, I don't get it. While he did not see the knife, that's a pretty big admission. As it was in Kleinman's pocket, he had the reasonable belief that Clairman was armed, which is confirmed by the evidence in the case. You can't use the existence of the knife in the pocket to prove that he had a reasonable belief that he was armed. To claim that you have a reasonable belief that somebody's armed, you have to have some indication, something that would tell you that he's armed. And simply having pockets is not enough. The document also claims a separate eyewitness saw Clairman get into a boxer stance with his hands appearing to want to fight. Well, if that's the case, then how is he reaching into his pockets? I don't know. I mean, it seems like those are mutually exclusive, but maybe not. Other details defense lawyers raised, which were also not in the criminal complaint, reference Clairman's toxicology report, which indicated Clairman was legally drunk. Of course, we don't have a toxicology report for Edgecomb because he took off and was on the lam for months. So, a little unfair there. The lawyers also said photographs taken at the scene captured open alcohol containers inside the Clairman's SUV. That is, Mr. Edgecomb, who was riding his bike recklessly, is not credible, as it is clear Clairman and his wife had been drinking and were likely under the influence, Edgecomb's lawyers wrote. Wait a minute, this doesn't make any sense. Let's read this. That is, Mr. Edgecomb, who was riding his bike recklessly, is not credible, as it is clear. Okay, there's something wrong with the English. Lawyers, man, I'm telling you, overrated. Can't write for shit. Of course, this could have been a bad translation on the part of the journalists, who are even worse. They added, Clairman was clearly intoxicated and armed with a weapon. A reasonable inference is that he was also belligerent and violent while under the influence, and that's pure horse shit. Okay? Being drunk and having a knife in your pocket doesn't mean you're belligerent and violent. Okay? I mean, sure, if you're belligerent and violent, being drunk would explain it, maybe. But just being intoxicated and armed with a knife doesn't make you belligerent and violent. It just means he happened to have a pocket knife on him, although I'm not sure what kind of knife that is. The criminal complaint omits critical information and mischaracterizes the facts of this case. The current narrative of the case is distorted and inaccurate, the defense lawyers wrote. Oh, cry us a river. I'm sure that Kyle Rittenhouse has got tears coming down his face, crying over your problem with mischaracterization of the facts. I feel that justice will happen for my son. This should not have never occurred. This should not have never occurred. Okay, she's not a lawyer. I'll let it slip. My son is a very humble person, and anybody that knows him knows this is not his character. Oh, okay. We're going to take a look at that here in a moment. So hold on to that thought. Remember, he's humble, and she mentions anybody that knows him knows this is not his character, which I assume she means violent. Okay, we'll see about that. Edgecomb's mother, Sonia Gordon, said during a news conference the day after WISN 12 published its story with the new video and documents. He is a man who has his whole life done the right thing. Yeah, we're going to put that to the test here in a minute too. He was hunted right in our own backyard. A brother like you and I was hunted, another Edgecomb supporter said Wednesday. No, he wasn't. Okay, let's be clear here. Edgecomb might be in the right. This might have been a perfect case of self-defense, but this was not a hunting. Okay, it looks like they got into an argument and Clearman may have chased him down to settle the score. That's not hunting. And I really wish that we would get away from this really flamboyant, hyperbolic language. Why can't you just simply say that he was defending himself? A man got mad at him, attacked him, he defended himself. Why can't we just express these things like that? Instead, staying away from this hunted crap. And by the way, it says here, right in our own backyard. Oh, I'm sure that really matters. What the hell difference does that make? Are you saying that this had happened in the neighboring city, that it would be no big deal? That it would somehow lessen what happened? It doesn't matter if it's in your own backyard. Edgecomb is scheduled to return to court Wednesday for a final pretrial hearing ahead of a scheduled January 3rd trial date. At the news conference, supporters of Edgecomb questioned whether the criminal justice system will treat him as it did Kyle Rittenhouse, who was acquitted on murder charges when a Kenosha County jury ruled he acted in self-defense when he shot 3 men in August 2020, killing 2 of them. We'll find out when the evidence unfolds. I'm sure that if the evidence points towards self-defense, Edgecomb will be okay. However, I've got some issues here with Edgecomb's story. Now, I'm not privy enough to be able to claim that he's guilty. He very well may have acted in self-defense. We'll learn more over time. But a lot of the narrative here has been cast very much in his favor, but somewhat unwarranted. Now remember, let's go back and hear what they said about him. My son is a very humble person, and anybody that knows him knows that this is not his character, okay? He is a man who has his whole life done the right thing. Okay, let's take a look. I looked up Theodore Edgecomb's past criminal behavior and basic troubles with the law. And we start off, this is the earliest one, carrying a concealed weapon, guilty plea, disorderly conduct, and use of a dangerous weapon. Charges were dismissed. We then have another case of disorderly conduct, guilty due to a no contest plea. This looked pretty minor, probably public intoxication or something like that. Domestic abuse, temporary restraining order. Domestic abuse, temporary restraining order. Well, somebody out there thinks that he doesn't always do the right thing. And then we have domestic abuse assessments, disorderly conduct. We have 3 domestic abuse charges here. Substantial battery, intent to do bodily harm. We have disorderly conducts. By the way, these were dismissed on defendant's motion. Well, I wonder what happened there. Oh, let's take a look. State's essential witness failed to appear. State has no alternative theory of prosecution. And you know who the witness was? The victim. Gee, I wonder what that restraining order was about in that previous filing. So it looks to me like his domestic abuse partner was terrified of him and didn't want to show up in court to testify against him and has a restraining order against him. Now remember, he's always done the right thing and he's humble in character. But we're not done yet. He looks like he has a paternity suit against him. And we have here a whole bunch of drunk driving problems and carrying a concealed weapon. So let's see here. We have a cause of injury while operating with PAC. That's basically drunk driving, hurting somebody. Operating a firearm while intoxicated. Resisting or obstructing an officer. Disorderly conduct. Carrying a concealed weapon. And another cause injury, operate while under the influence. Now, these are all misdemeanors. and still open. And that's not the end of it. It looks like he got pulled over, refused to take a test for intoxication after being arrested. Well, I don't know if this was a traffic offense. Yeah, intoxicated driver. So the actual character of this person primarily centers around, he's violent. It looks to me like he has a domestic partner that's really terrified of him. He's been arrested for domestic violence on a number of occasions. The only thing that saved his skin was that his witness, the victim, didn't show up in court to testify against him. It looks like he has severe problems with alcohol, and he has gun charges against him, along with a battery. So let's go back. My son is a very humble person, and anybody that knows him knows this is not his character. He is a man who has his whole life done the right thing. Okay, so you see, this is one of the problems when you just let people spout off these ideas, these statements. You put them in print and everybody buys into it. Nobody bothers to look into his criminal past. A journalist could have done this at this point. Here we have witnesses claiming he's the greatest guy in the world. Well, let's go into the WCCA database and let's see if he hasn't had any trouble in the past. They didn't bother doing that. And this is the problem with the mainstream media today. There's no sense of fairness. Now, let's take a look at the comparisons here with Kyle Rittenhouse. Well, Kyle never had any priors at all. Well, he had the one instance where he lost his driver's license because he was speeding or something like that. I forget. So he had a traffic violation, but that was it. This dude has been in a lot of trouble. Now, how much of that is admissible in court? Not much. This is a case where all of the pro-Edgecombs, anti-Kyles, and you know what I'm talking about, the people who are anti-Kyle are going to be all pro-Edgecomb, right? And they're going to sit there and say, well, yeah, you can't use those priors. Oh my God, those are in the past. The law doesn't allow you to bring up prior convictions. That would be so unfair. You'd be trying that person not on the actual event itself, but on something he did in the past, right? And they would be right. But when it came to Kyle's schoolyard fight, they had no trouble wanting that entered into the court records. Well, hell yeah, look at him. He's punching that girl. We need to have that in front of the jury so that they can see that and they can see what kind of person he is. Do you see the hypocrisy? Most of those prior convictions of Edgecomb are not going to be admitted for the same reason why the schoolyard fight was not admitted, as well as the CVS video footage. It's propensity evidence. And the anti-Kyles are all for dismissing propensity evidence when it's somebody that they like on the stand. But when it came to Kyle, oh no, Judge Schroeder was fascist. Oh my God, what a white supremacist. He's being paid by the defense. He must be. So yeah, there's all kinds of this crap that's going to be taking place here. You see the hypocrisy already, crossing state lines, not turning himself in, prior convictions. You're going to see all kinds of crazy distortions of logic. And so I would ask the pro-Kyles out there, when it comes to Theodore Edgecomb, be consistent. If you don't think that fleeing a scene of a crime makes a person guilty, then you shouldn't think that Theodore Edgecomb is guilty just because he fled to Kentucky. And similar arguments. I'm going to be doing a lot more on this case because there's going to be a lot of what would have happened to Kyle if he had been black that they're going to try now to use in this case. But these are not the same cases. Completely different. They have to be settled on their own merits. Like my videos, subscribe to my channel.